Madam Chair and members of the committee, Ian Huyett appearing for Cornerstone in strong support of Representative Cordelli's 2332H. I would maybe just note, as someone who's followed litigation in this area pretty closely, there are probably a few different changes in here that I would suggest that I think could make this amendment even stronger and more likely to succeed in court. But I do want to be clear that we endorse and would support the amendment as Representative Cordelli has drafted it. This is the first amendment or bill that any legislative body in New Hampshire has seen this term that could even plausibly restore the efficacy of our prohibition on teaching discrimination, both in terms of overcoming the district court injunction and doing something to assure agency implementation. These were two independent problems with the original law, problems that faced the original law, not that inheriting the original law. Different attorneys, including attorneys from different state agencies like the Department of Justice and the Department of Education, have come before this committee and committees like this one on bills that only adjusted the scienter requirement or the mental state requirement on the prohibition on teaching discrimination. And those attorneys have said things to you like, we would like only the scienter requirement to be changed, or it would help us for only the scienter requirement to be changed. But no attorney, including from any agency, has ever looked this committee or a committee like this one in the eye and said, I've read Judge Barbador's opinion and only changing the scienter or the mental state requirement will overcome the injunction and restore the efficacy of the law. And I don't think any attorney could say that to you in good faith. What Representative Cordelli has done here is he has taken account of each of the major problems facing implementation of the prohibition on teaching discrimination and done something to address and remediate each of those problems. This is the first amendment or bill that any committee in the general court has seen of which that is true. And I would be happy to go through and discuss any of the legal changes in this bill and why they're necessary and helpful.
Representative Selig?
Thank you. Just very briefly, if we could ask this attorney to specify for who he represents and the nature of that organization.
I believe he stated it at the beginning of his testimony.
Cornerstone is the only full-time Christian advocacy organization in New Hampshire. We represent over 100 churches around the state. And just to refresh your memory, our particular interest in this legislation is we were the leading organization in the state that assisted parents in filing reports of violations of the original prohibition on teaching discrimination.
Okay, I would prefer if you wanted to go through.
Yes, thank you, Madam Chair. I would love that. All right, so paragraph 3 is around lines 13 through 16. And here, Representative Cordelli has addressed some specific racial groups, although he's noted including but not limited to, and he's just listed the few largest racial groups in the United States, and said, to be clear, prohibitions here apply to teaching, targeting any of these racial groups. And the reason that this is here is that the principal issue in Judge Barbadoro's letter opinion in joining the prohibition on teaching discrimination was Judge Barbadoro said, this is a neutral blanket statement that says you cannot teach that any racial group should face discrimination or that any racial group is inherently racist or privileged. But Judge Barbadoro then said that, in his opinion, there was a problem with that, which is that discrimination targeting people of European descent, which we call affirmative action, is qualitatively different than other kinds of discrimination because, he said in his letter opinion, that discrimination is motivated by an attempt to remedy past discrimination. And so he said, if this law is going to prohibit teaching that white students should face remedial discrimination, it needs to spell out explicitly whether this prohibition includes discrimination against white students. And so the way that this amendment responds to that is by saying, to be clear, this was always clear. The intent of this is to prohibit teaching discrimination against any group, including people of European descent, people of sub-Saharan African descent, Hispanic or Latino people, etc. Then on paragraph 4, this says, and the key lines here are 18 through 19, that a report to the Department of Education of a violation of the Educator Code of Conduct shall justify investigation. The reason this is necessary is because not that there was any problem with the original law. The original law was quite clear. It had one paragraph saying that you may file a report with the Human Rights Commission, and then in the following paragraph it said you may file a report with the Department of Education. This is an Educator Code of Conduct violation. The Department of Justice and Department of Education both chose to construe that simply because, as I understand it, one paragraph came after the other as saying you must file a report with the Human Rights Commission and exhaust your HRC complaint before you can even file a complaint with the Department of Education. There was nothing in the RSA that said that. It was simply multiple remedies were in the law and one came after the other. That was the first time ever. I've been practicing in New Hampshire since 2019. That was the first time I've ever seen anyone even try to argue because one remedy follows another in a statute. The first is a necessary exhaustion requirement before you can go on to the second. But they use that argument to say, we, the Department of Education, are not even going to investigate these reports until the Human Rights Commission deals with them, which is very convenient because the Human Rights Commission has numerous, as a government audit showed, unresolved complaints going back to the Ronald Reagan era before I was born, and often sits, I think the average time for resolution of any complaint is something like 7 or 8 years, according to a government audit. So none of those complaints are likely to be acted on. So this resolves that by clarifying Department of Education can investigate. And then just two more items I'll note here. Paragraph 6, which is 23 through 26. Discrimination shall not be justified by special considerations for any racial group. This speaks specifically to the alleged ambiguity raised in the federal district court's opinion, which is this idea that because of past discrimination, remedial discrimination against white students and citizens is justified. And that can no longer be said to be an ambiguity because the legislature is addressing it here and saying we reject that construction. This is not true. And then finally, I'll just note the scienter requirement is addressed in here as well. And the scienter requirement is helpful to address. There was a little section at the end of the letter opinion from the federal district court saying a scienter requirement or a mental state requirement would help make this more clear. So we do support that change, but as I noted, I don't think there is any argument that any attorney could make to you having read that opinion that just changing the scienter requirement would restore the efficacy of the law, even in terms of just the district court injunction. I'd be happy to take any questions about any of that.
Thank you. Thank you. Representative Murray.
Thank you. I have two questions, if I may. One, just for clarification, the other remedy or action that was mentioned previously was also a private right of action, which you did not mention currently. Just to be clear, is that correct? There were several.
That's correct. Original law included a Human Rights Commission complaint, private right of action, or Department of Educator Code of Conduct violation.
Thank you. And then follow up, if I may. And then I am curious with respect to line 24, if you are directly referencing or linking affirmative action with this statement, if you can be explicit here.
Well, my understanding of the intent of this amendment is that this is a repudiation of the construction in the district court's letter opinion, and the district court's letter opinion said affirmative action or discrimination against white students because it's remedial is uniquely justified, unlike other kinds of discrimination. That's important to address if the general court wants to overturn that district court injunction, because that was an alleged ambiguity in the statute. And so here the legislature would be speaking to that alleged ambiguity and saying, no, we reject that construction. There is no difference in whether discrimination can be taught based on what race the discrimination is targeting.
Any other questions? Seeing none, thank you.
Thank you.